First time I've been in the courthouse in over 3 days. Judge called, said he wanted a word with me. If he could ask me a favor, if I could come by his chambers today.
Which judge?
Blackmore.
That's impressive. It's not that often some judge seeks my company. You should be honored.
I'm not so sure about that. You want to know what was on his mind?
I am all ears.
Well, he's not running for retention for another 2 years, so he wasn't asking for a contribution. Not just yet. Nope, he had another fish to fry. And so, he asked me if I'd like to sit down in one of his plush, overstuffed chairs and perhaps smoke a cigar, like we were old friends or something, and that's when I started to get nervous. Turns out for good reason, too.
You had no idea what was on his mind.
Clueless. I was about to be blindsided. And His Honor walked through the window and started talking about the weather. That's when he decided to stop dancing. Turned to me and said, just as nice as key lime pie, about some 15-year-old kid who tried to sell a gold pocket watch last week in New Iberia.
Near the Texas border?
Maybe 70 miles from here. The gold pocket watch was engraved with the initials AJT. Ring a bell?
AJT.
Andrew J. Thomas.
Wasn't he the guy that was
Shot dead in his home shop 5 times. So they drag the kid back here and accuse him of murder, at which point he confesses. Twice. In writing.
Did the kid have a lawyer present when the confession was squeezed out of him?
The son of a bitch shot one of our neighbors dead in cold blood. And your only question is if somebody was holding the poor little delicate Tyke's hand when the cops closed in.
He is innocent until proven guilty.
Says who?
Maybe the kid found the watch, or maybe he got it from the real killer. Maybe he bought it at some pawn shop.
That's when the judge has the nerve to look me in the eye and start in on his sales pitch about how the kid is penniless, how he has no family, no home, how he's a drifter who left school, and how he'll need a lawyer to represent him at trial.
Do you mean to tell me that you have been appointed by...
And it is my turn, says the judge, my venerable duty, to take this pro bono case, so the kid doesn't have to walk into court without counsel.
It is an honor that you've been selected. You should be proud.
It is a nightmare. What kind of a miracle of a defense am I supposed to pull out of my ass? The watch speaks for itself, and the kid confessed.
Well, I can think of a couple of things you could do for starters. Like maybe going to visit that kid in his jail cell. Maybe going to hear his side of the story.
I plan on visiting my newest client in the next day or two. You Bobby Joe? Bobby Joe McKracken?
I suppose. Who's asking?
Your lawyer, Attorney Morrison. Mind if I join you?
I got a lawyer.
And your trial is less than 2 weeks away.
I got a trial? Says who?
You're accused of murder. They say you killed somebody here in town.
Who says that?
You got any family?
Mom and Dad is both gone. Don't exactly know where to... Should I be talking to you? Are you a cop?
I am your lawyer, and I'm here to prepare you for your trial.
Oh.
How far are you getting to school?
6. I think. Don't exactly recollect. I had to work on a farm.
Got any brothers or sisters?
9. Maybe 10. I'm not sure.
Where do you live?
Here and there. I go where the props is from.
How old are you?
15. Nate?
They say that you shot a man. Shot him 5 times.
I ain't never held no gun before in my hand. I wouldn't know how to shoot one.
They said that you tried to sell the watch of the man who got shot.
I took that watch from another guy.
Who?
I don't know. I just came upon him in the ballroom. Then I pawned the watch. After that, the cops grabbed me while I was working with the crew. All I did was try to sell the watch.
They say that you confessed to the murder.
I don't know what you're talking about.
Cops say that you wrote down on a piece of paper that you shot and killed Andrew J. Thomas.
I'm not good with words. So the cops, they told me what to write. Them cops promised if I wrote down the words that they said, then I can go home. So I did. But they locked me up anyways. I don't exactly recollect the words I read.
Do your people know you're in jail?
Doubt it. I've been on my own a long time now.
Well, here's what I'm thinking to crack.
Bobby Joe. You can call me Bobby Joe. Just about everyone calls me Bobby Joe.
About the last thing you want to do is take the witness stand.
I don't know what you're talking about.
You shouldn't testify. Say anything during the trial.
That don't make no sense. I didn't kill nobody. Shouldn't I be talking to the judge or somebody?
The problem is you have the dead man's watch. How are you going to explain that?
Easy. I snatched that watch from another guy sitting at the honky-tonk.
That just goes to prove that you're prone to engage in criminal activity.
Do what?
And the other problem is that you gave a written confession. Actually, 2 of them. So if you say anything during the trial, the district attorney will want to know if you was telling the truth. If you say you was telling the truth, they'll make it look like you did so voluntarily. And if you say you wasn't telling the truth, he will make you out to be a liar. So it might be best if you just keep your mouth shut.
But I didn't kill nobody.
If you don't say anything during the trial, the district attorney will have to prove your guilt without your testimony. Nobody saw the dead man get shot, and the cops lost the gun that probably shot him. Your case is circumstantial.
It's what?
I'll just have to convince the jury that the confessions was coerced. That you didn't mean to tell the cops you was guilty.
Like I said, the cops promised if I write down what they said, then I can go home. So I just did what I was told.
Gentlemen of the jury, thank you for your attention during this brief but important trial. There's no need for me to waste your time with a lengthy closing argument. You've heard all the undisputed facts that I've proven during today's proceeding, and so I expect you to do your duty and find the defendant, Bobby Joe McKracken, guilty of murder in the first degree. Clearly, McKracken here lay in wait near the garage of the poor, unsuspecting victim, Andrew Thomas, one of your fellow citizens, and shot him 5 times dead in cold blood during a home burglary. How else could McKracken have come into possession of Mr. Thomas' gold watch? Then the defendant tried to pawn that watch. And that, of course, proved to be his undoing. It only took authorities a day or 2 to track him down on the farm and to bring him back here to the scene of the crime and for justice to take its course. Now, defense counsel has argued that nobody saw McKracken shoot the victim and that maybe the eyewitness at the pawn shop was mistaken. But that don't matter none, gentlemen of the jury, since as you have learned during this trial, McKracken here confessed to being a murderer. In fact, he confessed in writing on 2 separate occasions. Stands to reason, nobody confesses to murder unless they're guilty. You heard the confessions read during the trial, but I'd like to read them aloud again one more time since those statements prove beyond any doubt that McKracken here is the murderer. The first confession was made to the arresting officer at the time of his capture. I, Bobby Joe McKracken, now 16 years old, I stole the gun from Mr. O'G's at St. Martinville, Louisiana, and killed Andrew Thomas November 9, 1944, or about the time at St. Martinville, Louisiana. There's a secret about me and him. I took a black purse with card 1280182 in it, $4 in it. I also took a watch on him and sell it in New Iberia, Louisiana. That's all I'm said. I throw gun away, 38 pistol. As if one confession wasn't proof enough, the defendant made a second confession when he was returned here to the parish jail. Yes, Bobby Joe McKracken confessed that he killed Andrew Thomas November 8, 1944. I went to his house about 11:30 p.m. I hid back in his garage about half hour. When he come out the garage, I shot him 5 times. That's all I remember. A short story. Snarly. Bobby Joe McKracken. I expect you gentlemen to do your sworn duty and return a verdict of guilty. By doing so, you will assure that the ghostly soul of poor Mr. Thomas, your slain neighbor, will finally rest in peace in his grave.
Attorney Morrison, do you wish to present a closing argument to the jury?
Yes, Your Honor.
Gentlemen of the jury, the district attorney has failed to prove the state's case, which was based entirely on the faulty so-called eyewitness testimony of an aged pawn shop broker with failing eyesight who hesitatingly identified my client as the kid who came into the shop to try to sell the pawn. Came into the pawn shop to try to sell the watch. Now, plenty of 15-year-olds look just like my client, and that is a fact. Now, you may be thinking to yourself, why then did McKracken write those 2 so-called conflicting confessions with different dates when he allegedly committed the murder? Well, think back to when he was 15 years old. Still went behind me. The cops promised McKracken that if he simply wrote down what they asked him to write, he could go home. So he did. You see, there's no evidence, nothing, no gun that was ever tested from friends. Nobody actually saw the shooting take place. Some other kid probably tried to pawn the watch. If McKracken was the actual murderer, he would have ran far away from here. Instead, the cops picked him up down the road and he's still gathering the crops because he didn't know that the cops were looking for somebody who maybe looked like him. If he had actually sold the gold pocket watch and received a bag of money, he would have been on Easy Street. He wouldn't have had to be working under the hot sun, but he was still working the crops because he was broke. And he was innocent. I had no idea that there was any reason to hide. Them are the reasons that I didn't ask any questions at all of the district attorney's so-called eyewitness, because my client is innocent, and so there was no need to ask them any question. Gentlemen, it is time. You are a jury of McKracken's case. Find him not guilty. Especially because that's what he is. An innocent youth. It's in these.
All right, gentlemen of the jury, you've heard the testimony and the closing arguments of learned counsel. Now it's time for you to head on over across the hallway to the jury deliberating room and to remain there until you come upon a unanimous verdict of guilt or of innocence. You can tell the bailiff when you've reached a decision. If it gets real late, we'll feed you something for dinner. You're dismissed from the courtroom.
It's nothing quite like the smell of a good 25-cent cigar. Don't you guys think? The cheap stoves just don't have the same quality or aroma.
Says you. Smoking that smelly thing makes all our clothes stink. And I wear these here same pants to church every Sunday. It's hard enough trying to breathe in here, even with the windows open.
I've got extra cigars if anyone is interested. Hard to have a serious discussion without a cigar or two, and that's a fact.
Can we get back to business? We've been talking here for almost half an hour, and we still don't have no unanimous decision. Didn't the judge say we need to be unanimous?
Problem is, nobody seen the kid pulling the trigger. It's hard to tell who might have been the shooter. The only evidence that suggests the kid was even involved is that gold watch. Like the lawyer said, maybe the kid simply took the lousy watch from somebody else. Who really knows?
It's open and shut the way I see it. Open and shut. Did you guys notice the defendant's guilty eyes? His face alone says he's done it. Otherwise, why would he be sitting in court now, facing to get charged? And confessed to the murder not once but twice. It's plain as nose on your face. You confess and you're guilty.
I ain't so sure about that. Back when I was a 15-year-old kid, I would have wrote anything if it meant the cops would release me and I could go back home. This kid don't have much learning. Somebody, a parent, a lawyer, somebody should have been there to protect him. And another thing, the cops lost the gun before it could be tested for fingerprints. The pawn shop owner says he wasn't positive McKracken was even the guy who tried to sell the watch.
That don't matter none. The kid was really innocent. He would have took the witness stand and explained his side of the story. Instead, he just sat there with them, guilty eyes. I agree with Clem over there. The kid has them guilty eyes, for sure.
You can't let that influence your decision. And the judge already told us the kid was under no obligation to testify.
You actually think anybody believes that's nonsense? If you're innocent, you've got to stand up in court and tell everyone. Somebody killed old man Thomas and nobody but this here kid has been charged. Cops don't make mistakes like that. The district attorney wouldn't have gone to trial if he wasn't sure the kid was guilty of sin.
We've been here close to an hour. I got chores to do at home. Let's take another vote. Them that thinks he's guilty, raise your hands.
Looks like 11 of us says the kid done it. You, pal, is the only one holding out for innocent. How can you be so stubborn when the evidence is as plain as the nose on your face? Wasn't you paying attention in court?
I just ain't so sure the kid is guilty, and I sure don't like being pressured to change my mind. You shouldn't condemn somebody to death unless they deserve to die. I don't think the district attorney proved his case beyond reasonable, whatever the judge said in court.
We don't all agree. They could keep us here overnight. They could even make us deliberate again tomorrow. And the next day, too. Look, I got cows to milk. Tell you what, I will flip this here quarter. If it comes up heads, you got to agree to change your mind. Fair enough?
The defendant and his counsel will rise. The jury, having returned with a unanimous verdict of guilt, this court is prepared to impose sentence without further delay. Attorney Morrison, do you have any motions on behalf of the defendant?
None that I can think of, Your Honor.
Very well. And now, this 14th day of September, in the year of our Lord, 1945, you, Bobby Joe McKracken, are to suffer death in the manner provided by law under the mandatory death penalty provision of Article 740-30 of the Criminal Code of Louisiana. In accordance therewith, A warrant is directed upon Sheriff E.L. Restweber, the warden of St. Martin Parish, to carry out the execution of defendant McKracken by causing to pass through the body of the said body, Joe McKracken, a current of electricity of sufficient intensity to cause death, and the application of such current through the body of the said Bobby Joe McKracken is to continue until the said Bobby Joe McKracken is formally pronounced dead. There being no further business before this court, court is adjourned.
Can I finally go home now?
Archie, you gonna drink it all? I sure could use another sip myself. Need to relax in this line of work and lugging those Sparky around and see takes a lot out of a body.
Just a sip. It's gotta last to our next official duty this afternoon.
That's some of the best rotten gut uncle ever brewed.
Well, it doesn't grow on trees, that's for sure. I don't understand why they sometimes schedule two of these here sit-downs on the same day.
I know. After all, the prison ain't going nowhere special.
You're drunk? You're always drunk.
Am not. I've been near spill the chop. You gotta keep a clear head in this line of electrical work, and everybody knows where all these straps and wires and cords gotta go out. Yeah, shit ready gets operational.
Who's getting it this morning?
I heard tell of some kid that killed somebody. Now don't forget, you got a schedule to keep and no time to lose. After we're done here, we gotta take old Sparky back in the truck and head over to Gainesville. Now, memory serves you well. It's the brown wire that's coming out of the wall, that's the positive, and the red wire, that's the negative. What's the other way around when they turn those Sparky to the left? Bring enough gas for the generator. I hate when it starts to sputter.
Shall we pray? Lord in heaven, extend your mercy on your servant McKracken, who is about to enter your heavenly kingdom.
Yeah?
At this time of need, we call upon you, O Lord, to extend your gracious love and protection on this young man as he begins his next journey.
Journey? I'm going somewhere?
My son, you may pass through the pearly gates unto eternal bliss, if only you have faith. It matters not, you may have sinned while temporarily here. Even a murderer may enter the kingdom of heaven, if only you have faith.
How to corn from?
Corn fine, F-E-I-N. Lots of people make that mistake.
Father.
Yes, my son?
Do you think that I killed somebody?
For truly it is written, judge not, for ye shall not be judged.
Where did you get your faith, Father?
Initially from my dear parents, God rest their souls. They attended church every day and extended their faith onto me.
Never met my father. Don't know where my mother is. Father.
Yes, my son?
They was about to fry my ass like some omelet about a half hour. Ain't you a little curious as to whether I killed that man they said I killed?
My calling is to save thy soul. For as I said, judge not, for ye shall not be judged.
Same with that free lawyer they gave me. He never got around to asking me neither. I got a feeling though. He thought I was guilty.
I beg your pardon?
That mouthpiece Morrison. He never asked if I killed nobody. Just told me to keep my mouth shut. Maybe the jury forget about the confessions they put out here.
My son, confession is good for the soul.
Is it? They haven't seen that done me much good. I just want to go home.
And soon ye shall, my son. Soon ye shall. You only need to have faith.
Father, I got half an hour left. If I tell you something, you can take it to the bank. And that's a fact. You know what I mean?
With so little time, perhaps we shall pray together. Heavenly Father, we beseech you in this moment of need to look upon your servant McKracken, who is about to go up.
Father, it went down like this. I didn't kill nobody. I was just sitting at this bar stool drinking soda, and this guy next to me starts going on and on about this gold watch he's wearing, and how it's real pricey. So one thing led to another, and when he got up, I followed him out the door and I took it.
Took what?
I clunked him on his head and I took the watch. A real beauty. I'm guilty of rolling the guy and taking the watch. I admit that, but I ain't guilty of nothing else.
My son, there is precious little time. Shall we pray? Holy Father, look with compassion upon your servant McKracken and usher him into your kingdom of
Not
heaven.
guilty. And that's a fact.
Did you enjoy your lunch? Mrs. Resweber always tries to make it real special. You know, when it's the last one. But what did you think of that dessert?
They didn't bring me none yet.
Oh, that's a shame. Maybe some other time. And speaking of time, it's arrived, McKracken. Have you made your peace with God?
It's kind of hard to tell, boy. Maybe you should ask the father here. I'm not sure he knows either.
Last time we was here, I told them to invest in some new fuses, maybe a breaker panel or two. They built these prisons like 100 years ago, and they don't upgrade nothing. Then they expect me to be some miracle worker. You gotta stretch some of these cords tight just to plug into the wall socket. I used 2 of these extensions already. They better not pop out.
Nothing's easy, Archie. The backup generator seems a bit sluggish, too. What would they use that same old crack fan for? I don't think it's out of time. But does anybody listen to me? Nope. So I'm just the assistant parish executioner. The low man on the totem pole.
That's totem pole, you moron!
You sure? Hey, time for another sleeve to understand the lightning.
Take a seat, McKracken. Don't make this no harder than it has to be. You, got any last words, McKracken? Then, by the power vested in me as warden of this here prison, I am directed by the death warrant issued by Louisiana Governor Jimmy Davis, setting May 3rd, 1946, at high noon as the date of execution. Your sentence will now be carried out. Goodbye, McKracken.
Turn it off!
Try to switch again!
Turn it off!
Stop the damn execution and unstrap the prisoner! I've seen enough for one day. Just take McKracken back to his cell, and when he comes to, somebody get him a medic.
Be careful there, Zeke. Don't touch old Sparky. She could still be activated.
I don't think so. You don't waste most of the juice on that kid.
As you probably know, Albert, the executioners botched the electrocution last week. See, they don't have killed someone first time around. I heard tell, Governor. Well, I asked you here today because I need to be sure that everything's done legal-like. The death warrant I issued for May 3rd, 1946, electrocution has expired. That is correct, Governor. You will need to issue a second warrant. Fair enough. No reason to delay matters. I intend to sign the paperwork, schedule the execution for next week. That is the correct procedure, Governor. If the kid doesn't want to sit in the chair a second time, he could to take an appeal and try to have the second one delayed.
This whole mess has been an embarrassment to the state of Louisiana. The newspapers picked up on this fiasco.
No need to be embarrassed, Governor. This is not the first time difficulties were encountered during electrocution.
No kidding?
I've done a little research. Actually, that honor goes to the great state of New York. History tells us that on August 6, 1890, William Kemmler, a drunk who killed his common-law wife with a hatchet, became the first electric chair victim. They threw the switch, and for 17 seconds, the victim was subjected to the introduction of electricity. Two physicians who were present determined that Kemmler was dead, so they turned off the juice. Upon further evaluation, it was found that the condemned man's heart was still beating, so additional current had to be applied. About 4 minutes later, Kemmler was determined to be really dead. The record reflects that afterward it took several hours for the body to cool off. It's interesting to note that Thomas Edison helped design the first electric chair, despite the fact that he was opposed to the death penalty.
I don't understand.
Edison was engaged in an ongoing dispute with his competitor, George Westinghouse. Westinghouse asserted that alternating current should be utilized in electrical devices. Edison championed the use of direct current. In order to demonstrate that Westinghouse's form of current was dangerous, Edison designed an electric chair that used Westinghouse's alternating current. To prove his point, Edison staged a public demonstration at Coney Island, New York, where he used Westinghouse's alternating current to electrocute a circus elephant named Topsy.
I fired those two drunks that botched the first electrocution, and I've engaged an electrician to confirm that the chair is in proper functioning order. That the second electrocution should go off without a hitch. Let's just hope that that kid doesn't do something stupid and file some frivolous appeal.
Highly unlikely, Governor. He doesn't have two nickels to rub together, so finding an attorney won't be easy.
Hello? Yes, this is Bertrand de Blancombe. Is this Attorney James Scully Wright?
At your service. My secretary advises me you're located in Louisiana?
Yes, Counselor.
Call me Jim.
Ah, thank you. Please, call me Bertie.
Fair enough. What can I do for you, Bertie?
Well, I am told that you are often called upon to argue before the U.S. Supreme Court.
Guilty as charged. I've had that honor on occasion.
Well, you should know, before I take another minute of your time, this call won't generate a nickel in fees. I'm dealing with a pro bono case from start to finish. I'm seeking your assistance before the U.S. Supreme Court. It's my understanding that you have, on occasion, taken on such burdens, and the issue has involved constitutional significance.
I'm listening. You haven't scared me away yet. Tell me your tale.
I'll get to the point. About 6 months ago, a 15-year-old kid, transient migrant worker, is charged with the murder of a member of the St. Martinville parish right down here in Louisiana.
Is the kid white or black?
Black.
Go on. Sorry for the interruption.
The adolescent defendant, named Bobby Joe McKracken, was picked up when an aged pawnbroker with bad eyesight claimed that the defendant had tried to sell him the victim's watch. He was arrested and interrogated without the assistance of counsel. Along the way, these two cops coerced from him two random, disjointed, so-called written confessions.
Did the kid ultimately recant the confessions?
Yes, said he stole the watch when he assaulted the actual murderer. You see, He spoke with his court-appointed attorney only once for 30 minutes before they picked a jury. The half-day trial took place September 12th. The jury returned a verdict of guilty in less than 45 minutes. Now, rumor has it, there may not have been unanimity, but pressure brought them down the holdout.
What was the sentence?
Dead by electrocution.
Uh-oh. The kid's still alive?
Sorta.
Sorta?
But now here's where the story takes a strange twist. Now, this trial was a mockery of the judicial system. The cops found what was probably the murderer. They sent the handgun off to the FBI for fingerprints. The gun gets lost in the mail and is never recovered. There's no stenographic transcript taken during the trial, so there's no lower court record. The court-appointed defense counsel was, at best, disinterested and inadequate. He never cross-examined the state's witnesses. He never put McKracken on the stand. And he never objected to the so-called written confessions. McKracken never got to hear. He never got to tell his side of the story. And since there was no lower court record, the incompetent defense counsel was unable to appeal to the higher Louisiana courts.
If the case didn't make it through the state appellate system, how then has it progressed all the way to the United States Supreme Court?
Now we come to it. The murder occurred November 8, 1944. The half-day trial took place September 12, 1945. On March 29, 1946, the state of Louisiana prepared to execute our defendant, Bobby Joe McKracken, who, at the time, was 16 years old. The state executioner and his assistant, prison trustee, showed up at the parish prison. It's not yet high noon. They are both drunk. They proceed to connect a portable electric chair to the prison's ancient and inadequate power system, which includes a backup gasoline-powered generator. Now, they strap this kid in the chair, pull the switch, and are successful only in administering first, second, and third-degree burns. McKracken's hair catches on fire. Some of his clothing is set ablaze, and despite several attempts, they are unable to kill him. They carry him back to his jail cell, after which the electric chair and its inadequate power source undergo evaluation.
McKracken's still alive?
2 weeks later, McKracken had recovered sufficiently enough to sit up in his prison hospital bed and take nourishment. They fed him some of the dessert they failed to serve him as part of his last meal.
How did you get involved?
About a month ago, a man shows up at my office. He says he's McKracken's uncle. He tells me the story and implores me to do something. And at first, I found the story to be implausible, but when I realized it was true, it occurred to me that several applicant issues, some possibly on a federal level, might require review.
Well, certainly double jeopardy. Cruel and unusual punishment.
Yeah.
Equal protection under the law, just to name a few. Some problems, however.
Yeah, like what to do with the defendant now? Should McKracken be set free since he has arguably already served his punishment? Should we suggest a lesser jail sentence? At any rate, I initiated a petition in the federal district court, proceeded up to the circuit court levels, and lo and behold, the Supreme Court has granted certiorari. The judges want to hear oral argument. And that's where you come in. Now, Jay, might you consider helping this kid out?
Mr. Justices, If we take the argument of the state of Louisiana to its illogical conclusion, that state can once again, with impunity, strap Mr. McKracken to the electric chair a second time and cause him to be a victim of cruel and unusual punishment, the most bizarre form of double jeopardy. Contrary to the equal protection clauses of this country's Constitution.
While your argument is compelling, I fail to understand how a possible remedy can be promulgated by this court. Granted, the fickle hand of fate may have orchestrated an unusual situation. That is, the possibility of a second administration of an electric current. However, this was not an intentional attempt by the state of Louisiana to subject Mr. McKracken to a form of torture engaged by an unfeeling governmental entity. To the contrary, by mere chance and no more, there existed an insufficient electrical current to carry out the valid sentence of the state court. Upon second, properly monitored application, this situation will probably be remedied.
I share my brother Justice's dilemma. Furthermore, consider this scenario. Suppose Mr. McKracken had been strapped in the electric chair and by some happenstance a minor stream of electricity, barely felt, had been caused to enter his body. Are you in effect asking this court to determine how many electrons and the intensity thereof that must be experienced before we establish that a second administration of the punishment would be contrary to the tenets of the federal Constitution?
I'd like to follow up on that hypothetical as well. I'm not so sure that the sentence of the Louisiana court has thus far been carried out. If one looks at the definition of electrocution as found in Webster's unabridged dictionary, it requires, and I quote, that sufficient electrical current pass through the body in order to cause death. I don't believe that act has occurred yet. Mr. McKracken may have been subjected to some degree of shock, but arguably he hasn't yet been electrocuted.
I have great compassion for Mr. McKracken, who may have experienced a difficult moment. However, if this court were to find that a breach of the Constitution has in fact occurred, what remedy awaits him? Open the jailhouse door, pat Mr. McKracken on the head and wish him well? Are we to override the express sentence of the trial court as determined by a jury of his peers and substitute some jail sentence in place of the death penalty? After all, the young man was found guilty of the murder of a fellow citizen.
It is the compassion of a nation that exists as the true measure of its place in history. If we ignore the sanctity of life based on a technicality, if we permit the unfeeling administration of a punishment upon one individual who in all probability was innocent of the original crime charged, by turning such a blind eye, we call into question the composition of our collective moral timbre. Today, this court has the honor and the obligation to right a wrong, to proclaim that even the most humble among us is entitled to equal protection under the law, assured that the mandates of our blessed Constitution apply without exception to all who appear before this court. To render any other ruling would be a step back from the principles, from an acknowledgement of those principles upon which this country was founded.
Thank you, Counselor, for your compelling arguments and its thoughtful insights. The court will now close this proceeding and retire, ultimately to issue its opinion.
Up next for discussion is the Bobby Joe McKracken case. Briefs were received and have been distributed. You gentlemen will recall that oral arguments took place last month. What are your thoughts? Is there a consensus?
May I begin?
Certainly, Andrew.
I've studied the record as submitted. We must assume that the state officials tasked with the responsibility of executing the defendant carried out their duties under the death warrant in a careful and humane manner. There is nothing in the sparse lower court documents to suggest to the contrary. Accidents happen for which no man is to blame. But the state officials displayed incompetence or sought intentionally with cruel forethought to administer multiple applications of electricity, I might be compelled to view this peculiar occurrence in a different light.
Well, I tend to agree. When an accident with no suggestion of malevolence prevents the consummation of a lawful sentence, double jeopardy has not occurred tantamount to a denial of federal due process during the proposed execution.
Nor has anything taken place here that amounts to cruel and unusual punishment in the constitutional sense. The defendant's suggestion that because he once underwent the psychological strain of preparation for electrocution, that such an ordeal should preclude him from again being subjected to a second procedure is without merit. Simply stated, the fact that the defendant has already been subjected to a current of electricity does not make his subsequent execution any more cruel in the constitutional sense than any other execution. The fact that an unforeseeable accident prevented the prompt consummation of the sentence cannot, it seems to me, add an element of cruelty to a subsequent execution.
Furthermore, were we to rule otherwise, a precedent would be set requiring us in the future to determine the minimal amount of electricity, the administration of which would constitute a constitutional violation. Indeed, no electrocution has yet taken place, and as a result, the sentence of the court has not yet been carried out. A review of Webster's unabridged dictionary confirms that an electrocution only takes place if sufficient current passes through the body to cause death. That has not yet occurred. Therefore, any decision by us that ignores the lawful sentence of the Louisiana court would obviously be premature.
A punishment only becomes cruel when it involves torture or lingering death. The record is devoid of any such act.
The defendant's final argument that he was represented by incompetent counsel at time of trial is without any factual basis. The record suggests to the contrary. Counsel pursued an intentional strategy predicated upon the defendant exercising his right not to incriminate himself by taking the witness stand. Had the defendant testified, he would undoubtedly have been cross-examined regarding the two voluntary confessions he submitted to the police.
I concur. The Federal Bill of Rights protects an accused from being a witness against himself. Similarly, the Due Process Clause of the 14th Amendment does not preclude the freedom of the state to enforce its own notions of fairness in the administration of criminal justice. The first attempt by the state of Louisiana to execute the defendant was the stuff of innocent misadventure. As a result, we must abstain from interference with state action, no matter how strong one's personal feeling of revulsion against the state's insistence on its pound of flesh.
It's noteworthy that any remedy extended to the defendant would be fraught with uncharted legal minefields. Do we even have the authority to set aside a valid jury verdict? Can we substitute a prison sentence in place of a sentence of death? Do we simply open the jailhouse door and set the defendant free based upon an inadequate source of electrical power? Are we authorized to propose some form of executive clemency? Can we substitute our vision of justice for that pursued by the state of Louisiana?
My fellow justices, with all due respect, you have failed to focus upon the issue at hand. I have briefly caucused with Justices Douglas, Murphy, and Rutledge, and we believe that the unusual facts before us require the judgment of the Supreme Court of Louisiana to be vacated, and that this case be remanded for further proceedings not inconsistent with our findings. Those proceedings should include the determination of certain material facts not previously established, including to the extent, if any, to which electrical current was applied to the defendant during the attempted electrocution on May 3rd, 1946.
The 14th Amendment to the Constitution of the United States provides, "Nor shall any state deprive any person of life, liberty, or property without due process of law." The capital case before us presents an instance of the violation of constitutional due process that is more clear than would be presented by many lesser punishments prohibited by the Eighth Amendment or its state counterparts. Taking human life by unnecessarily cruel means shocks the most fundamental instincts of civilized man. It is unthinkable that any state in modern times could ever envision the enactment of a statute expressly authorizing capital punishment by repeated applications of an electric current separated by intervals of days or hours until finally death shall result. But that is exactly the end result should the majority of this court follow its present reasoning.
A reading of the Louisiana statute that makes it clear that a second execution is unauthorized. It provides that every sentence of death imposed in this state shall be by electrocution, that is, causing to pass through the body of the person convicted a current of electricity of sufficient intensity to cause death, and the application and continuance of such current through the body of the person convicted until such a person is dead. The statute does not provide for electrocution by interrupted or repeated applications of an electric current at intervals of several days or even minutes. It does not provide for the application of electric current of an intensity less than that sufficient to cause death. It prescribes expressly and solely for the application of a current of sufficient intensity to cause death and for the continuance of that application until death results. In the case of capital punishment, it should be construed strictly. There can be no implied provision for a second, third, or multiple application of the current. There is no statutory or judicial precedent upholding a delayed process of electrocution.
It was the statutory duty of the state officials to make sure that there was no failure to carry out the sentence of the trial court. If the state officials deliberately and intentionally had placed the defendant in the electric chair 5 times, and each time had applied electric currents to his body in a manner not sufficient until the final time to kill him, such a form of torture would rival that of burning at the stake. I believe that remand of this cause to the Supreme Court of Louisiana in the manner indicated would not mean that the defendant necessarily is entitled to a complete release. It would mean merely that the Louisiana Supreme Court must examine the facts, both as to the actual nature of the punishment already inflicted and that proposed to be inflicted.
Well, it would appear at first blush that if no member of this court is inclined to reconsider, the final decision will reflect a 5-4 vote in favor of sustaining the Louisiana Supreme Court. Gentlemen, this informal discussion is concluded. I thank you for your valuable time and insights.
Another hard day at work, dear.
Had I known, before accepting the President's appointment to the Supreme Court, that I would have to battle on a daily basis such traffic as only Washington, D.C. has to offer, I might have thought twice before ascending to the bench. Going to and from court is truly a struggle. Really should provide a limo, don't you think?
I certainly understand, dear. Would you like some more potatoes?
And it doesn't help that 2 of the justices only recently returned after extended absences from the court. We're under considerable pressure to review a number of complex issues.
Anything of interest? Something you might share?
Actually, there is a truly fascinating case.
Tell me all about it, dear. You know how I always enjoy hearing about your thought-provoking cases.
Okay, you're just going to love this one. See, the state of Missouri enacted a tax on the privilege of doing business within its borders. Now, a vendor has to pay a penny for every $10 of sales transacted. Sounds simple enough, but how do you determine what sales actually occurred within the state? What if a purchaser places an order by phone while located in another state and the goods are ultimately mailed to that foreign location? You get my drift? And this is a self-reporting tax, no less. Now, the court heard oral arguments some months back, and today we published the formal opinion. Now, obviously, if the goods were ordered from out of state, then...
Pardon me, dear, but tax issues about Missouri don't really interest me, if you know what I mean. Does it really matter if some sales tax didn't get paid?
Business privilege tax? Sure it does. If vendors don't pay the tax, how will government be able to afford to stay in business?
Seems to me governments always find a way to keep operating. Oh, don't get me wrong, I certainly wish Missouri well, and I'm pleased the problem has now been resolved. You folks always come up with such good answers. But is this truly the most interesting case you've considered recently?
Yes, well, perhaps not. The court did issue another opinion this week, one that dealt with this kid in prison.
There's some more roast beef if you're interested. What young child in which prison?
I think I will have some more of your delicious roast beef. A kid named Bobby Joe McKracken. He may have shot someone and...
You're not sure?
Well, no, I'm not. But that's not the point. It doesn't matter whether he's guilty or innocent. The question is whether he can be electrocuted a second time.
Why would you electrocute the child twice, let alone once, if the poor soul might be innocent? I'm not sure I quite understand.
Well, it's not up to us to determine guilt or innocence. That was already decided by a jury of his peers.
Oh, other young children pass judgment?
Of course not. 12 mature citizens residing in the local community.
And where exactly did all this take place?
Louisiana.
Oh dear. Not exactly a hotbed of justice.
Hot or cold. That wasn't the issue we were called upon to address.
How old is he?
Who, McKracken? 15, maybe 16 now. He's been locked up for a while. Do you want to hear about this case or not?
Please do continue.
So, the defendant...
A child of 15 years. I own some socks older than that.
So, the defendant is sentenced to die in the electric chair.
Yes. Did you actually think that the Missouri business something tax case was more interesting than this?
So, on the day set to carry out the sentence, they strap this kid into the electric chair, pull the switch a couple of times, but they can't quite kill him. There wasn't enough electrical power.
Good God.
His hair caught on fire, but he didn't quite die. Well, the issue is really quite simple. Can Louisiana place the defendant back in the electric chair, or does such an act constitute a double jeopardy, a cruel and unusual punishment, contrary to the Equal Protection Clause of the federal Constitution?
And what exactly have you determined?
Well, it's not just me. 9 justices need to reach a decision. 9 of us, justices.
Was there ever a question in your mind what was the right thing to do?
No, it's not that simple. You see, we don't have the power to alter the sentence of the trial court. And actually, it could be argued that the sentence hasn't yet been carried out. And electrocution only occurs if the subject dies. And so we were called upon to decide whether or not.
There's some doubt in your mind as what to do. I hope you decide.
No. Now that's the interesting part. See, if an electrocution hasn't actually occurred yet, it would be premature for us justices to alter the sentence of the trial court.
Good God! You are not suggesting that.
I didn't go to law school so I could battle Washington traffic twice a day. I certainly didn't become a judge so I could be compelled to make life and death decisions. You think this has been easy? I really do prefer to rule on business privilege tax cases from Missouri.
Well, this whole process might be a little tough on McKracken, too. If we had a 16-year-old son, would you strap him in the chair a second time? Hopefully, dear, you did the right thing and you made the correct decision. You did do the right thing, didn't you, dear?
Just what is that exactly?
I did what the law requires. I can't be blamed for that now, can I? Who's there?
Do I know you? I don't think we've been properly introduced.
All rise. The judge is here. Pardon me, aren't you Justice Frankfurter? I mean, the Justice Frankfurter? It's kind of hard to tell when you're wearing pajamas.
Why, yes, I am.
Please be seated. Mr. Justice, you can sit right here. I understand you serve the Supreme Court of the United States.
Well, that's me.
Then you must be, like, really, really smart.
Sometimes, I suppose.
Well, that's good, because we sure could use your help. Do you know what's the brown wire that's positive and the red wire that's negative? What's the first positive?
I don't know. That's not actually my field of expertise.
What is?
What is what?
The field of what you just said.
Justice. I dispense significant quantities of justice, quite often on a regular basis. By the way, that left leg strap, that could be a little tighter.
Well, I guess we better get started. No time like the present.
Are you sure this is absolutely necessary?
Oh, of course it is. See, the Supreme Court recently ruled that we can fry people more than once until we get it right. Death by installment.
But that's double jeopardy.
Not according to a majority of the justices. I think the vote was 5-4. I've been on horses with worse odds.
But I'm innocent. Believe me when I tell you that, I wouldn't fib at a time like this.
Yeah, I'm not so sure that's relevant. See, the jury already made its decision.
But you're making a terrible mistake. Sitting here has helped me see the situation from an entirely new perspective. It's definitely more interesting than business privilege tax, especially when you're personally involved.
Does that mean the brown wire's positive or negative? I'd love to chat, but we have a schedule to keep.
I don't understand how you can be so cavalier. Life is precious. Just as soon as I awaken from this awful nightmare, I intend to do something about this entire unfortunate episode. I really do.
Mr. Justice, do you have any last words?
You betcha. Do something to wake me up!
Pardon the interruption, Governor. I know you said hold your calls, but this one might be important.
Who is it? I ain't even finished my coffee and sports page yet.
It says he's some judge or something. I didn't actually catch the name, but it sounded like some sort of hot dog.
Governor Davis here. Who's calling?
Good morning. It's Justice Frankfurt. Is this Governor Davis of the state of Louisiana?
Jimmy Davis at your service. Who'd you say you were? Justice who?
Justice Felix Frankfurter. I serve on the Supreme Court.
Which court? Felix who?
Frankfurter. And thank you for taking my call.
Frankfurt. Supreme Court.
I'm calling about the Bobby Joe McKracken case.
Whose case? Wait a minute. Is that the guy we tried to execute a while back? I recently signed another death warrant.
Precisely. He's about to be executed for the second time.
Yeah, I recall now, yeah. His execution's already been scheduled. What can I do for you, Mr. Justice?
Well, upon further reflection, it might be possible that you'll find that the second death warrant may have been issued in haste. I'm calling to ask that you reconsider.
Reconsider what? I was just following your court's order. Did you guys up there in Washington, D.C. recently conclude that there was nothing more to do and that the sentence of death could be carried out? Or am I mistaken? I sometimes get things confused.
A slim majority ruled that it could be carried out, but that doesn't mean that it must be carried out. You see, sir, as governor, you have the ability to invoke executive clemency.
But the criminal, after he ever killed one of my fellow citizens, someone who may have been a registered voter, is that what you're suggesting? Wasn't that your job? When you guys poked your nose in Louisiana's business, you could have reversed things and showed us hillbillies down here how things are done right. But you didn't. Let me ask you a question. Are the judges of the Supreme Court elected life terms?
Like, yes, we are. What has that got to do with...
I'm not. I'm running for re-election next year. Now, just supposing I was left to see a criminal go. What might the voters of the great state of Louisiana think next time they enter the voters' booth? Now, you guys had your chance and you blew it. If it's so important, why don't you just simply rewrite your opinion?
Well, that's the problem. Once a formal opinion has been issued, it can't be reversed until another case comes along.
Well, Mr. Justice, I don't quite see necessarily where that's my problem. You see, I'm a patient guy, and I'm willing to wait for the next case to appear. Now, why don't we both just relax, and you have a nice day, and we'll let justice take its course.
Hi, Attorney DeLong. Nice you stop by.
Bobby Joe, I got some news.
I heard tell.
You did?
Prison guard showed me today's newspaper. I'm in the paper. Again. Me. Bobby Joe.
The Supreme Court's rendered its decision. Brought you an official copy. Arrived in the mail this afternoon.
What's this here lump?
Oh, that's the raised seal of the court. See that area of the paper where the signatures appear? They take a device and they make an imprint right there. So you know you've received a verified copy. So each lawyer in the case receives a certified copy.
The prison guard said it was close. The decision was close.
4 justices have ruled that the judgment of the Supreme Court of Louisiana affirming execution should be vacated, and that it should not be subjected to electrocution until a determination. They ruled in your favor, Bob. There would be a delay, perhaps permanent. You see, they believe that death by installment is unconstitutional.
4 of the Supremes decided that? I sort of agree.
4 ruled in your favor.
And what about them other Supremes?
5 justices have decided differently.
That I should be put back in the chair? Is that what they said?
I am truly sorry, Bobby Joe.
5 to 4. Close. And when's it gonna happen? When are they coming for me?
Tuesday. Government signed the paperwork for this Tuesday.
Tuesday.
12 noon.
Turn it around.
Yes, Bobby Joe?
What's a pop?
Pop?
They say I'm gonna be dumping in Papa's grave. What's a pop?
It's a poor person, but listen, I don't want you to give up hope, all right? I put in a call to the governor, and I've asked him to reconsider.
Strange. Knowing the exact moment he's gonna die. How many people have an idea when their time's up? I've been thinking. I'll tell you what I'd like to have written on my gravestone. It took 2 times to kill an innocent man. It ain't necessary. When you know your time's come, you just get tired and you want things to end. I've been in this cage coming up on a whole year now. That's a long time. I don't mean no disrespect. I know you worked hard to make things right. Sometimes there's just nothing more to do. Things I can try. I can still do something. Funny. When they pulled the switch the first time, I thought I was dead. They come to me, I was still alive. It's kind of disappointing.
I don't understand.
It wasn't so bad. People think being dead. There's worse things than that.
Joe, I'm not.
Like being trapped in this here box for over a year for no particular reason. I ain't seen the sun in a long time. I used to hate working on that farm in the hot sun. Now I'd give anything just for an hour back then. Hey, I've been wondering, where them Supremes hang out?
The who?
Them 9 justices. It seemed to me they should have showed up personal, like, to hand me the news themselves. At least they could do. And another thing.
What's that, Bobby?
If the priest decides to come back again, I sure hope he has something more important to say. Last time he failed to bring any comforting words. I can help him out if he wants. That way he can use my words if he needs them to comfort the next guy they decide to try.
You found some soothing words?
Some people have been reading about my case in the papers. Some have followed up with what's been happening since my first execution. Some have sent words of encouragement and hope. I do surely appreciate their thoughts.
And it's true. Lots of people have been interested in your case. Lawyers, judges, law professors. Lots of good, caring people. Some of them even tried to contact me.
A while back, this guy wrote to me from Germany. We just fought them in a big war.
I recall.
This guy wrote to me in German. It took a while, but they finally got it translated for me. You want to see the letter?
Yeah.
Read that line there. The one I got underlined.
Right there. Mein Angstberg ist gestiegen, das mich so traurig macht.
Now read the translation.
My mountain of anguish has been climbed. It made me so tired.
Finally found him out. Took a while. You think that you'll remember me? I know I'll remember you forever.
Yes, Dr. Joe. I will never forget you. Not ever.
Glad to hear. That helps a lot. Truly do.